I have seen this before, not in headlines, in outcomes. There is a moment in the life of any republic when a court stops deciding cases and starts deciding the architecture of power itself. That moment does not arrive with thunder. It arrives with procedure, with a vote count, with language so carefully measured that most people read it and hear nothing at all. 8-1. That is the margin. 8-1 is not a close call. It is a declaration. And declarations, once made, do not wait for permission to take effect. The case moved through the system the way most consequential cases do, quietly, without the kind of spectacle that draws public attention. The Second Amendment Preservation Act, the mechanism at the center of this ruling, was itself a product of state legislatures acting in what they believed was their constitutional right. Several states passed versions of this law over the past few years. The logic was straightforward on its surface. If federal firearms regulations exceeded constitutional boundaries, states could refuse to cooperate with their enforcement. It was framed as protection, as a safeguard, as a firewall between state sovereignty and federal overreach. That is what it looked like from the outside. From the inside, it was something else entirely. The Second Amendment Preservation Act was not simply a gun rights measure. It was a structural challenge to the relationship between state and federal authority. Every state that passed it was drawing a line that said, we will decide within our borders which federal laws apply and which do not. That is not a minor procedural adjustment. That is a reimagining of how the federal system works. And the Supreme Court, in an 8-1 decision, drew its own line directly through the middle of it. Let me be precise about what happened, because precision matters here more than it usually does. The court did not rule that states have no rights. It did not rule that the Second Amendment is diminished. It ruled on something narrower, and, in its structural implications, far more consequential. It ruled that states cannot create legal mechanisms designed to block federal law from operating within their jurisdictions. Non-cooperation, as a formal policy framework, was found to exceed the authority that state legislatures actually possess under the Constitution. The Supremacy Clause, Article 6 of the Constitution, was applied not as a historical curiosity, but as a living operational constraint. Federal law is supreme. States cannot construct architectures designed to make it otherwise. 8 justices agreed. 1 dissented. That ratio tells you something important. It tells you this was not a controversial legal question among the people tasked with answering it. It tells you the ground had already shifted before the opinion was written. Now, here is what most coverage of this decision will focus on. The gun rights angle, the Second Amendment implications. That framing is not wrong, but it is incomplete in a way that matters. Because the Second Amendment Preservation Act was never only about guns. It was about whether states could refuse federal authority in a structured, legally defensible way. And the answer now is no, not through formal legislative mechanisms designed to create zones of noncompliance. The court has closed that door, and once a door like that is closed by the highest court in the system, it does not reopen, not unless the court itself changes its mind, or unless the Constitution is amended. Both of those are, in practical terms, events that do not happen on any timeline that affects the people currently living under the consequences. I want to spend some time on the Supremacy Clause, because it is the mechanism through which this decision operates, and mechanisms are where power actually lives. The Supremacy Clause was written in 1787. It was one of the compromises that made the Constitution possible. The framers understood that a union of states required some resolution of the question. What happens when state law and federal law conflict? The answer they wrote into the document was unambiguous. Federal law wins. Not sometimes. Not when it is convenient. Always. When there is a genuine conflict between a state statute and a federal statute, the state statute yields. This principle has been tested repeatedly. It was tested during the nullification crisis of the 1830s, when South Carolina attempted to declare federal tariff laws void within its borders. It was tested during the Civil Rights era, when southern states attempted to maintain legal structures that directly contradicted federal legislation. Each time, the Supremacy Clause held. The Second Amendment Preservation Act cases are the latest iteration of this pattern. But here is what is different this time, and what makes this ruling structurally significant beyond the gun rights debate. The states that passed these acts were not acting out of ignorance. They were making a sophisticated argument. Non-cooperation is not the same as nullification. A state can refuse to lend its own resources and personnel to federal enforcement without actually blocking that law from existing. This is a real legal distinction. It has been recognized in other contexts. Immigration is the most visible example. Sanctuary cities operated on exactly this model. They did not defy federal immigration law. They simply declined to assist in its enforcement. The Second Amendment Preservation Acts attempted to extend this model to firearms regulation. We are simply not helping. The federal government is free to use its own resources, The court rejected this. The majority found that these laws went beyond passive non-cooperation. They were designed not merely to withhold state assistance, but to actively obstruct federal enforcement. The distinction between withholding and obstructing is a legal one, but its practical effect is enormous. The states cannot simply pass laws saying, "We will not help." They must be more precise. And in being more precise, they lose most of the political power that the laws were designed to project. This is how power moves in a federal system, not through dramatic confrontations, through the quiet narrowing of available options. Let me talk about the numbers, because numbers carry weight that abstractions do not. 22 states have passed some form of Second Amendment Preservation Act or equivalent legislation. That is not a fringe movement. That is nearly half the states in the Union. Tens of millions of Americans live in jurisdictions where legislatures made a formal decision to resist federal firearms regulation. Millions of gun owners understood their state governments to be standing between them and federal enforcement actions they opposed. That understanding is now legally unsupported. The ruling does not mean that every gun owner in every one of those 22 states is immediately affected. But it means that the legal architecture those states built has been found constitutionally deficient. And that is not a temporary setback. That is a permanent change in the landscape of options available to state governments. There are governors who campaigned on Second Amendment protection. There are state attorneys general who have staked their reputations on the enforceability of these laws. The court has not told these officials they are wrong about guns. It has told them they are wrong about the mechanism. And in politics, the mechanism is often more important than the principle, because the mechanism is the thing that actually produces results. These states will have to find new ways to express their position. Some will challenge specific federal firearms regulations on Second Amendment grounds. That is a different kind of fight. It is a fight about the substance of the law, not about the structure of the federal system. It is a fight that the court has, in effect, directed them toward by closing the structural alternative. This means the Second Amendment debate is now being compressed into a narrower channel. It is becoming a debate about what the Second Amendment actually permits and prohibits, and that is a debate the court itself will ultimately decide. The single dissenting justice deserves attention, not because one dissent can change an outcome, but because dissents often function as roadmaps for future litigation. They identify the arguments that remain available for the next case. Future cases will pull on that thread. The decision has been made. Its immediate legal consequences are clear. What is less clear is how the federal government will use the authority this decision has confirmed. The ruling does not compel federal enforcement of any particular firearms regulation. It simply removes the legal mechanism that states use to resist. Draft assessments from legal analysts suggest that federal agencies will move carefully in the immediate term, precisely because the political visibility of firearms enforcement is extremely high. But careful is not the same as restrained. And the infrastructure for enforcement, now unobstructed by state-level legal barriers, exists, whether it is used immediately or not. Infrastructure, once built, does not disappear because it is not immediately activated. Let me return to the pattern, because the pattern is what matters most here. A state or a collection of states identifies a federal action they find unacceptable. They build a legal mechanism to resist it. It is framed not as defiance, but as cooperation refusal. For a period of time, the mechanism works. Courts allow it. The federal government tolerates it. And then the Supreme Court rules. And the mechanism is dismantled. Not always quickly, not always completely, but consistently. The Supremacy Clause is not a suggestion. It is an architectural feature of the constitutional system. And every time a state attempts to build a structure that contradicts it, that structure will not survive the test. This has happened before. It will happen again. The specific policy area changes. The mechanism changes. But the structural outcome does not. There are currently active legislative efforts in multiple states to create similar non-cooperation frameworks in other policy areas: immigration enforcement, environmental regulation, tax compliance. Each of these efforts draws on the same constitutional logic. Each of them will, if the current trajectory holds, reach the same conclusion. Federal authority is supreme. States can advocate, states can litigate, but states cannot construct formal legal mechanisms designed to prevent federal law from operating within their borders. That is the line. The court has redrawn it, and it is drawn where it has always been drawn, if you go back far enough to find where the line was originally placed. The 8-to-1 margin in this case is not just a legal outcome, it is a statement about institutional consensus. When 8 of 9 justices agree, it means the legal community at its highest level has reached a conclusion that is unlikely to be revisited. It means lower courts will follow this reasoning without significant resistance. The legal landscape has shifted in a way that is durable. 22 states built legal structures designed to resist federal authority. Those structures have been found constitutionally deficient. The political energy that went into building them did not disappear. It will be redirected, but it will be redirected into channels that the court has approved. which means channels that the court can also control. Power does not vanish when a mechanism is removed. It moves, it finds new forms, but it moves within the boundaries that the highest court in the system has drawn. And those boundaries, as of this ruling, are narrower than they were before. That is not opinion. That is the current state of the law. And the current state of the law is where history begins.